is the same as for fraudulent misrep, the fiction of fraud. Why do we say that? Because of section 3.1, so liable, okay? Pepsi Cola case and Roy Scott and Rogerson, the English case, which is very controversial because you're treating a person who's merely negligent as if they are dishonest, okay? All right, so there you are, everybody. That's a very quick example of how useful the definitions are, okay? The basis of your answer was your definition of misrepresentation, and the rest should just flow on, okay? Good. And then, of course, that goes for the other definitions as well, like exemption clause, okay? An exemption clause is what? Anybody?
Defense.
Yes, it is. But what is it? That's how it's used. A clause in a contract which seeks to exclude or restrict what? Liability for either negligence, breach of contract, or misrepresentation. Bingo, that's your definition. And that sets you up nicely for answering an examination question, because if your client is being sued for negligence, or breach of contract, or misrepresentation, they may be able to rely on an exemption clause as a defense. Ta-da. Will the exemption clause be effective as a defense? Well, it has to pass 3 tests, remember. Incorporation. Is it in the contract by signature or by notice? Does the wording cover the wrong? That's a matter of interpretation. And then, of course, legislation. And the CECO will render an exemption clause either totally void or make it subject to the test of reasonableness, okay? But again, the basis of your answer is the definition of an exemption clause. The definition tells you it's a defense, okay? So again, must know the definition. And frustration, of course, similar. Frustration, who can define frustration for me? Frustration occurs, negligent but not dishonest. Negligent but not dishonest. Negligent but not dishonest. Okay. Frustration occurs when? You forget the definition? No, frustration occurs when? Without fault of either parties, a contractual obligation has become either impossible, illegal, or radically different from that which was undertaken by the contract. Good. So from the definition itself, you see frustration is raised as a defense to what? Breach of contract. Good. Because you're saying, well, I can't perform. Look, why? Because it's impossible to perform. Good defense. Or it's illegal to perform. Good defense. Or it's radically different. Remember, radically different. Those cases, Crellin Henry, Contrast, Herne Bay, and Hutton. I was going to have my hair cut, but I haven't got my hair cut. And normally the barber I go to in Hong Kong really cuts it short. I was going to turn up with very short haircut today. Would I look different? Yes, but not radically different. It's still me. Okay, so there you are. So look how useful these definitions are, but make sure you know them and know how to use them. The other definition, of course, is offer, acceptance, consideration. Okay. Must know the definitions. Must know, must know, must know. Do I need to memorize them, Mr. Green? Yes, you do. Do you want to do well in the exam? Yes, well, memorize your definitions. But not just memorize them, know how to use them, okay? And you'll do very well. I mean, students who do well in the exam obviously know their definitions. And then you know where to go. The definitions guide you to the rest of your answer, okay? And remember, use subheadings if you can in your answer, and the best subheadings are issues. So your subheading should have a question mark. I mean, is that an offer? Question mark. Is there acceptance? Question mark. Has the offer been withdrawn before acceptance? Question mark. Okay. With misrepresentation, statement of fact or opinion? Question mark. Has there been induced? Question mark. Okay. And it gives you good structure to your answer. You know exactly what you're talking about, and the examiner knows what you're talking about. That's even more important. Okay. So remember, in your examination answers, don't have paragraphs which are too long. because the longer your paragraph, the easier it is for you to get confused. There's probably more than one issue, okay? So generally keep your paragraphs relatively short, okay? And same with your sentences, okay? Good. All right, so quick, so any other questions arising from that? Good. Okay, well, if you haven't got questions, I've got questions for you. What's an offer? An indication of a willingness to be bound, uncertain. Okay. And you know all the rest, okay? Okay, good. So draw up your list of must-know definitions, have it on one sheet of paper and keep looking at it. Take a photo of it, okay? Put it on your phone. Oh, hello. So when you're going home on the MTR, start looking at your definitions, okay? You know, when it's on, you're on the MTR, people are, hello, what's he looking at? Well, if they see you looking at definitions from contract, they're going to get bored and you won't be bothered. So good. Okay, remedies, everybody. Quick run through. Here's your overview. Now, in the exam, there are just two areas which you might get a question, the must-know areas. One could be a liquidated damages clause. The most common remedy for breach of contract is damages, which is a remedy at law. Okay, but you can also get equitable remedies, specific performance, or injunction. So the equitable remedies are must-know because there have been past exam questions asking you to list out the remedies in equity. Okay, so remoteness of damage, should know, not must know. Damage for non-pecuniary loss, again, should know, not must know. These are all pretty well should know, not must know. This one I would classify as should know, bordering on must know. And this is very useful in practice. Remember the two big issues when you go to court, liability and quantum of damages. And usually, often the court spends much more time on assessing damages than actually on finding liability. And the courts encourage liquidated damages clauses. Now, what is a liquidated damages clause? It's a clause in a contract which specifies a certain amount of damages should there be breach. Now that can be an actual number or it could be a formula, okay? And it's an attempt by the parties to estimate the amount of damages. But important to note, everybody, and this goes with tort law as well, the aim of damages is to compensate for loss. It's not to punish the guilty party. So damages are compensatory. They are not punitive. Important point, general point to bear in mind. Okay, so when it comes to these liquidated damages clauses, they must be a genuine pre-estimate of loss so that the innocent party can be compensated for the loss. Okay, and if it is a genuine pre-estimate of loss, it will be a liquidated damages clause, and that will govern how much money the innocent party gets. Okay, so that's basically it on a liquidated damages clause. Could come up in part A of the exam, 10-mark question. Explain what is meant by liquidated damages clause. Okay, good. And then the other must-know bit will be the remedies in equity. Either specific performance or an injunction. They are both court orders. You've got to go to court and get a court order. That's the first thing to make. And of course, the court will be exercising its equitable jurisdiction. Specific performance and injunction are just two of the different types of remedies in equity. The remedies in equity can range from just, you can actually get damages in equity. And one good quote that you might want to write down, which is a quite good one, the court will, I always forget it, I should write it down. I looked at that, there's a very good quote describing how the courts come up with their remedies in equity. the court will mould the relief to give effect to the equity. I like that. The courts will mould, M-O-U-L-D, the relief to give effect to the equity. What does that mean? The court will look at the facts of a particular case and come up with a remedy which is suitable. Okay? Mould the relief, shape the relief to give effect to the equity, to give effect to the fairness, if you like. Okay? Good. But in particular, the particular remedies in equity which we focus on our course are specific performance and an injunction. Specific performance, a court order for a party to perform their obligation under the contract. Okay. And remember, the maxims of equity apply. Delay defeats equity. He who seeks equity must do equity. The clean hands doctrine. Okay, good. So that's really all you need to know with regard to specific performance. It's a court order in which the court orders a party to perform their obligations under a contract. Worth noting that it's probably, it's where the subject matter of the contract is unique, such as land, okay? So where damages is not a suitable remedy. But you won't get a remedy in equity if it requires constant court supervision. The other remedy, an injunction, the court orders to stop a breach, can be either prohibitive or mandatory. Okay, and what's the difference between all three? Well, this is a good PowerPoint where B promises A to build a wall, he doesn't do it. So what's the remedy? Specific performance. Where B promises A not to build a wall, but B threatens to do it. Well, you want to stop him doing it, a prohibitive injunction would be the appropriate remedy. And then finally, if B promises A not to build a wall, but he does build it, well, then you seek a mandatory injunction, MI, to compel B to demolish the wall. Okay? But again, I like that quote. Right? The courts will mould the relief to give effect to the equity. Good quote. Okay? All right, so that's it on remedies. Anybody, any questions, queries, worries, anxieties, comments, suggestions? Okay, good. So let's move on to the taught part of the course. So the first topic we're going to look at is vicarious liability. And of course, with vicarious liability, we restrict ourselves to the employer-employee relationship, bearing in mind that there are other relationships which can give rise to vicarious liability. Okay, now your course manual has quite a lot of detail on vicarious liability. So you're wondering, what are the must-know cases with regard to vicarious liability? I think there are 5 must-know cases on vicarious liability. That's not bad, 5. And with those 5 cases, you've covered just about every issue. All right, so let's go through. First of all, must know the definition of vicarious liability. The employer is responsible or liable for damage caused by the torts of his employees acting in the course of employment. That's a must-know definition. So if you get any question on vicarious liability, first thing you do is write down the definition. That will then help you identify the issue, and that will either be, is the worker an employee or an independent contractor? That's the first issue. The second issue, is he acting in the course of employment? Okay? Now, depending on the question, you should also tell the examiner you know that vicarious liability is a form of strict liability. What is strict liability? It is somebody being liable even though they're not at fault. So the employer is not at fault, it's the employee, but the employer will be liable, strict liability. And remember, the main function of tort law is compensation. So the employee may not be a good target to sue because he doesn't have any money, but the employer is a much better target because they should at least have insurance. Okay? So try to work in that general principle in any tort answer. The main function of tort law is compensation. And so vicarious liability does fit in with that principle quite nicely because a plaintiff generally will get compensation because they can sue the employer. By the way, what happens if you sue the employer? Can the employer get an indemnity from the employee? Yes, but good luck because the employee may not have much money. Okay, and if he is still an employee, you might fire him because of the tort. I don't know. Okay, so there you are. Good PowerPoint. This one, good PowerPoint. Okay, put a big circle around this one. Must know. Okay, so moving on to the first issue, is the worker an employee or independent contractor? There's really only one absolutely must-know case, and that's the market investigations case. And market investigations case gives us a rather neat summary of what the test is. Is the worker in business on his own account? Page 17. Is the worker in business on his own account? Now, your course manual has another 5 or 6 pages on this, but really there's only one must-know case, market investigations. Make sure you know the test. Is the worker or person in business on his own account? If he is an independent contractor. If not, he's an employee. And the two cases I like to contrast are the Privy Council decisions. Privy Council, remember, Court of Final Appeal before the handover. Li Ting Sang contrast Cheng Yun. And remember, Li Ting Sang started off him losing, so the result was, sadly, but then he finally won in the Privy Council. So the result of Li Ting Sang was that it ended up happily. Joke, sort of, but it helps you remember the result of the case. Right. Now, I mean, how do you know? Well, the court will look at various factors or indicia, same thing, such as who provides the equipment, who hires the helpers. So if the worker provides the equipment and hires the helpers, that indicates independent contractor. Also, how is the worker paid, and other factors such as does the worker wear a uniform of the company? Well, that would indicate employee. Okay, right. And in an examination question, you don't know. You use your magic 2-letter word. If the worker is in business on his own account, then he's an independent contractor. Okay? But you should mention briefly that the courts will look at the relevant factors or indicia, and they will have to come to a decision. And unfortunately, in Cheng Yun, the final result was they did find he was an independent contractor. Okay. Even though he won initially in the Labour Tribunal, LT's Labour Tribunal, and also then in the High Court. The High Court was the court of first instance before the handover. So what's the court of first instance in Hong Kong now called? Court of first instance. Okay. What's the Court of Appeal in Hong Kong now called? Court of Appeal. What's the Court of First Instance in Court of Final Appeal, sorry, in Hong Kong now called? Court of Final Appeal. I was just sitting there before class today, huh? Court of Final Appeal. I mean, before the handover, Li Ting Sang and Cheng Yun had to pack their bags and fly all the way to London. Stupid, isn't it? Really? Now they just go into Central. Okay, so to a large extent, Hong Kong's better off after the British left as far as the law is concerned. You don't have to travel so much anyway. Okay, all right, good. So good PowerPoint, this one, good PowerPoint. Market investigations, absolutely must know case. Li Ting Sang, Cheng Yun should know, but try to work it in. Okay. And the other issue, of course, will be, is he in the course of employment? All these cases, forget. They're interesting, but they're history, they're gone. go straight to the close connection test. Lister and Hesley Hall, House of Lords, Ming Ann and Ritz-Carlton, Court of Final Appeal, must know, must know. So that gives you 5 must know cases. All right? So first of all, Lister and Hesley Hall gives us the test now. Is the employee's tort, whatever the tort is, in Lister and Hesley Hall it's the tort of battery. Ming Ann, it was the tort of negligence because the driver was in a traffic accident during his lunch hour. So is the employee's tort so closely connected with the employment that it is fair and just to hold the employer liable? If you can remember that, good. If you can't remember that wording in an exam, just say the courts will apply the close connection test. That's probably good enough, but it would be better if you could remember what's in inverted commas. Is the employee's tort so closely connected with the employment that it's fair and just to hold the employer liable? Now, of course, who decides what is fair? Who decides what is just? The judge in a particular case. And in Lister and Hesley Hall, the law as it stood before this case seemed to indicate that the warden was not in the course of employment because of sort of outside working hours that he was abusing the boys. But the House of Lords said, well, we think we should find him liable. I mean, because the public is very much against this sort of activity. So they broadened the test and they say, well, come up with this close connection test. All right, good. And applied by the Court of Final Appeal and Ming Ann and Ritz-Carlton. There have been questions in past exam papers based on the facts of Ming Ann and Ritz-Carlton, okay? So what were the facts? Well, the driver was wearing the hotel uniform, driving the hotel car, went out for lunch because he didn't like the hotel food, and he was involved in a traffic accident. He was negligent. But was the employer liable? Well, the court applied the close connection test. Was the driver's negligence so closely connected with the employment that it was fair and just to hold the hotel liable? Okay, and the court said yes. He was wearing the hotel uniform, driving the hotel car, and this is Vicarious, Mr. Justice Vicarious line, which everybody likes. The hotel had an interest in making sure the employee was well fed, because well-fed employees work better and they are much more productive for the employer than employees who are hungry. Okay. All right, good. So what's on the screen? Everybody must know, must know, must know, and just 5 must know cases on vicarious liability. Okay. Market investigations, giving us the test for who an employee is. Plus, I would suggest Li Ting Sang and Cheng Yun, plus Lister and Hesley Hall, plus Ming Ann and Ritz-Carlton. You've got it. You've got everything you need to know on vicarious liability of just 5 cases. Arguably just 3, okay, but I would suggest 5 would be good, okay? Anybody any questions then about vicarious liability? And of course, what does vicarious mean? It means substitute, coming from the word vice, okay? So if President Biden were to die, who would become the president of the US? The vice president, who's what? Kamala Harris. Okay, good. Okay. That would be interesting, wouldn't it? Okay. All right, good. Okay, moving on now to negligence. So let's go through the must-know cases on negligence. First of all, of course, everybody, make sure you know the elements of negligence, sort of what's on the screen, a little bit long, probably a good paraphrasing of the elements of negligence, which I've told you before, I think. A, it's A, B, C, D. Reminds me of that Michael Jackson song, Easy as A, B, C, do, re, mi. whatever. Okay. By the way, if you get the A, B, C, D, you'll be singing in the exam, but do so quietly because you know you're going to nail it. How come it went off? Oh, okay. So there must be A, duty of care owed by the defendant to the plaintiff. Then there must be B, breach of the duty of care causing, C, causation, damage, D, which is not too remote. Okay, that would be good enough in an exam answer. Okay. And then, of course, it's up to you on the facts of a question to decide which one of the elements in negligence is at issue. Okay? And probably good to go right through, where is it? Straight to this PowerPoint, because this is a good summary of all you need to know on duty of care. Okay? Now, when it comes to duty of care, always look to see what type of damage has been suffered by the plaintiff, because that will dictate how much time you need to spend on whether there is a duty of care. Okay? So if the damage suffered by the plaintiff is directly caused, personal injury, or property damage, dead straight, Donoghue and Stevenson, okay, reasonable foreseeability sufficient. Okay. So watch out for that in examination questions. If you're in a traffic accident situation and the plaintiff suffers, you know, personal injuries, or usually it's personal injuries, sometimes property damage, then you simply say a duty of care will be owed. In fact, you could quote Cheng and Wu from the previous case, Cheng and Wu, which the court said all car drivers owe a duty of care to all other road users, including pedestrians. Okay. So in a traffic accident case where the plaintiff has suffered directly caused personal injury, duty of care is not a big issue. Obviously you mention it, yes, but then you probably spend most time in a traffic accident on the second element, is there breach? Breach is always an issue in traffic accident cases. We'll come to that a bit later. However, if the damage suffered by the plaintiff is either nervous shock or pure economic loss, duty of care will be an issue, because for both nervous shock and pure economic loss, then the other element of proximity is relevant. Okay? So with nervous shock, remember, with regard to nervous shock, the must-know cases, first of all, Hinds and Berry, which says it must be a recognised psychiatric injury, and Wong and To, I think it's also the Hong Kong case. Okay. So with regard to nervous shock, I'd say there are 6 must-know cases. Number 1, Hinds and Berry, stroke Wong and To. And then number 2, Page and Smith. Is the victim of nervous shock a primary victim or a secondary victim? A primary victim is one in fear of his own safety in the line of impact, in which case it's pretty well Donoghue and Stevenson. That's Page and Smith, House of Lords. Must know Page and Smith. And in exam questions, look to see whether the victim is in the line of impact. You don't have to actually be hit, as long as it's a close scare. So if I were to throw my bottle at somebody, oops. Did I tell you about my snake in Harcourt Garden? Did I? No? Okay, I was sitting there contemplating teaching a class. I think it was you lot, wasn't it? Yeah. And collecting my thoughts, and I was sort of dozing off. I had my shoes off, and I sort of looked up. Suddenly a snake appears from the drain, 4 to 6 feet long, and sort of brushes past me within about 5 or 6 feet. Well, okay. So it reminds me, I'd be a primary victim if I suffered nervous shock. I mean, but you can't sue the snake. Maybe I could sue the Hong Kong government, because you're not supposed to have snakes in public. Anyway, I don't think it was venomous. I think it was a rat snake. Okay, but I mean, goodness gracious, luckily, I've had plenty of experience in dealing with snakes, because on my hikes I've come across a few, including a king cobra. So what do you do when you see a snake? Stand perfectly still. And then they will stop. And so you sort of wait for them to go. And sometimes I lose patience, so I throw something at them. All right. Okay, so there you are. But make sure you know who a primary victim is, everybody, all right? If you're there in the line of impact, in fear of your own safety, you're a primary victim, okay? So watch out for that. If you're not a primary victim, of course, you're a secondary victim. What are the must-know cases on secondary victims? Well, perhaps I should change my PowerPoints and go straight to that. Yep, I'll do that. But this is a good summary, okay? Good summary of this one. So just to expand on some of the points, because I haven't got all the must-know cases on nervous shock on the screen here. So let's go to those ones. Okay, so they're your first two must-know cases on nervous shock. Hinsonberry, Wong and Toe. The injury must be a recognised, diagnosable psychiatric injury. What do you mean by psychiatric? Mental illness. Okay, and appreciate that medical science has moved on. In the early 20th century, the medical profession and legal profession didn't recognise mental illness. So people used to say, "Yeah, what's wrong with you? Come on, grow up. That you're stronger than that sort of thing." Right? And it's only after, I think, the First World War, where a lot of the soldiers came back shell-shocked, post-traumatic stress disorder, that the medical profession recognised mental illness. Okay, so this is why the law with regard to psychiatric injury has developed more in the late 20th century. Okay, so they're the first two cases, and of course nervous shock has to be shock-induced. And then remember, Page and Smith tells us who a primary victim is, one who's actually, if you're actually physically injured, sure, that's fine. You can be physically injured and suffer a mental illness as well, so you get that. So obviously, but even if you're not physically injured, but if you're in the line of impact, you are still a primary victim, okay? And the duty criteria are the same as in directly caused physical injury. In other words, Donoghue and Stevenson. Okay, so that's the second must-know case on nervous shock, Page and Smith. Third one, well, these ones, forget, there's all history, this is a bit of history, so forget this one. But you go straight to Alcock. And Alcock says a secondary victim has to show the extra element of proximity. And proximity has three aspects: proximity of relationship, proximity of time and space, and proximity of perception. Okay? So with regard to, so obviously Alcock is a must-know case, House of Lords. With regard to relationship, Alcock is your authority for the relationship one. Only parents and spouses are presumed to have the required proximity. But if you're in any other relationship, and in Alcock it was a brotherly relationship, you've got to prove close ties of love and affection. So you've got to come up with evidence of love and affection, which is probably easier these days because you've all got smartphones, okay? I mean, I was a bit slow with my phone the other day when the snake, I was going to take his phone, but he was fast. You know why he was fast? Because there was a bird coming down to get him. I mean, this is rather dramatic. I was just relaxing before class and I've got this drama of a snake and a bird coming. And it happened within 10, oh my goodness. Well, I haven't been to Harcourt Gardens since. Okay. Well, it's a nice place too, anyway. Okay, so there you are. And in Alcock, the brother failed to claim close ties of love and affection. So his action failed. Okay. So, and then with regard to proximity of time and space, must know McLaughlin and O'Brien stroke Chung and Lamb. McLaughlin and O'Brien is the mother who came to the hospital in the immediate aftermath of a horrible accident in which she saw relatives dead and others severely injured. Within about 1 hour of the accident itself, the court said no problem, that's sufficient closeness or proximity of time and space, because the mother suffered nervous shock. By the way, in McLaughlin and O'Brien, obviously the mother had proximity of relationship because she was both the mother and the spouse. Okay. And of course, she saw the effects with her own eyes, so there was proximity of perception. By contrast, Chung and Lamb, another mother, unfortunately, was told not in the immediate aftermath of the accident, but some time later. I think it was the next day. So the court said, sorry, no proximity of time. Okay. Which begs the question, well, where's the cut-off point? Well, the court will never tell you. I mean, what happens if the mother and McLaughlin and O'Brien got there 2 hours later? Probably still be all right. 6 hours later, who knows? Okay. So again, be prepared to use your magic 2-letter word if there's sufficient proximity of time and space. But these cases are good guides. And then proximity of perception, you've got to do it as we are now, face to face with your own eyes, okay? Communication through third parties will not be good enough for proximity of perception. Sort of should know, Alcock has left the door slightly open here. What about live simulcasts of dramatic events? Well, the courts might move with the times and say, well, it's almost as if you were there anyway, and so you could succeed with proximity of perception even though you didn't witness the event in person yourself. Okay, good. So it must know Inzenberry, Wong and Toe. Must know Page and Smith on primary victim and know the test. Was the plaintiff in the line of impact or in fear of his own safety? Must know Alcock on secondary victims, and Alcock is the authority on proximity of relationship. McLaughlin and O'Brien is your authority on proximity of time and space, plus also perhaps Chung and Lamb, and then Alcock is your authority on proximity of perception. Okay, so if you get that in the exam, quite a bit to write about. It's not too difficult because the facts are pretty dramatic and you'll get good marks. Okay, good. So any questions about duty of care with regard to nervous shock? Going, gone. Okay, so let's move on to duty of care with regard to the situation where the plaintiff has suffered pure economic loss. Could come up in part A of the exam. Could be either a full 20-mark question or perhaps half a mark question, but half 10-mark question. First of all, tell the examiner you know what pure economic loss is. It is loss which is not the result of either personal injury or property damage. Okay, so that's the first point to make. Secondly, if the damage suffered by the plaintiff is pure economic loss, there will not be a duty of care owed unless the element of proximity is established. So, how close, how proximate does the relationship have to be? Well, I like the quotation from Lord Devlin, equivalent to contract. In other words, very close. And those cases on, the courts have sort of come up with two elements. There must be an assumption of responsibility by the person making the statement, and then reasonable reliance by the plaintiff. Okay. By the way, we're talking about negligent misstatements here. So you can see this is where contract law and tort law overlap, because you can sue in negligence, but you can also sue in contract for misrepresentation. What is misrepresentation? A false statement of facts made by a party to a contract, which induces the representee to enter into a contract with the representative. If you're faced with a situation, do you sue in tort or contract? Go for contract for misrepresentation. Why? Because the remedies are much better under the misrepresentation ordinance. Okay? But the facts of a misrepresentation could also ground a claim for negligence, because the statement may actually be negligent itself. Okay? And whether or not there is negligence, the court will look at, is there an assumption of responsibility? Well, that's a bit like, is it a statement of fact or statement of opinion? Okay? And then, has the person been induced? Well, that's sort of like proximity a factor. Okay, so Hedley, Byrne and Heller is, I think, should know, bordering on must know, depends on the question. Okay, and the important thing to note, Hedley, Byrne and Heller deals with negligent misstatements, but this has been expanded to negligent acts. There's a case called White and Jones. Okay, so so liability for negligent misstatements, there must be an assumption of responsibility, as in Chowdhury and Prabhakar, in which the young man sort of said to his girlfriend, you can rely on me, I'm an expert on cars. So he assumed responsibility, and there was reasonable reliance because she was not an expert, he was. But what the young man should have done, of course, is had some form of disclaimer. Okay, I know I'm an expert on cars, but don't take my word for it. You shouldn't really. Okay. So Chowdhury and Prabhakar is an interesting case because the court found that there was a duty of care, even though it was not in a commercial context. It usually comes up in a commercial context where the person making the statement has special expertise in that area. Okay. In Hedley, Byrne and Heller, though, remember there was a disclaimer, basically an exemption clause, which was effective in Hedley, Byrne and Heller. Okay. So when we're talking here about negligent misstatement, clear overlap between contract law and tort law. Okay. But if you're advising a client, usually better to go in contract law under the misrepresentation ordinance. Okay. So you can also have pure economic loss with regard to negligent acts, not negligent words. And the leading case is White and Jones, okay, which says the Hedley-Byrne principle, HB principle, can be applied where pure economic loss is caused by negligent conduct, not just words. Okay. So, as I say, with regard to pure economic loss, number one, tell the examiner you know what it is. It's loss which is not the result of either personal injury or property damage. And the issue would be, is a duty of care owed to the plaintiff when the damage suffered is pure economic loss? Well, the answer will be, it only will be owed if the plaintiff can establish that other element of proximity. And that depends on the facts. Is there an assumption of responsibility by the person making the statement, and is there reasonable reliance? Okay. Good. So if you get, as I get a question on pure economic loss, probably a 10-mark question in part A. Okay, good. So any questions then about either nervous shock or pure economic loss? Right. And this is where I've come up with this. Well, this is the overview as well. So this is sort of repeat of the previous PowerPoint. Okay, so in examination questions dealing with negligence, look out for the type of harm suffered by the plaintiff. If it's directly caused personal injury or property damage, It's dead easy. It's pure. It's Donahue and Stevenson. All you have to show is reasonable foreseeability. But if it's nervous shock suffered by the plaintiff, well, first of all, tell the examiner you know what nervous shock is, Hinsonberry, stroke, Wong and Toe, and then make sure you know who a primary victim is. Primary victim in the line of impact or in fear of his own safety. Page and Smith is your case, House of Lords. And then as we've just been through, Alcott gives us the law on secondary victims. Secondary victim has to establish the other element of proximity, and proximity has three limbs: proximity of relationship, Alcott itself, proximity of time and space, McLaughlin and O'Brien, stroke, Chung and Lamb, and proximity of perception, Alcott. Okay, good. Students normally do quite well on nervous shock questions. Okay, good. And then with pure economic loss, make sure you know what pure economic loss means. And remember, if you are claiming a duty of care where you suffer pure economic loss, you've got to show the extra element of proximity as well, which means there must be an assumption of responsibility by the statement maker and reasonable reliance by the plaintiff. Hedley, Byrne and Heller, I think, is bordering on a must-know case, because that's quite a famous case. All right, so that's pretty well it on duty of care. Anybody, any questions, queries, worries, anxieties, comments? Yes. By the way, remember, the defendant owes, O-W-E-S, a duty of care. The defendant does not own, O-W-N. Which I think, if you look closely at your course manual actually does make that error somewhere. I marked it to be up to you to have a look, but yes. Now, your course manual's pretty good on tort law, generally. Okay, it was the original version was by one of my fellow lecturers, Hannif. Yes, there it is. Rewritten and updated based on material by Hannif McGull. Hannif McGull, really good lecturer on tort law. He's a barrister, not sure. Okay, good. And then, yeah, okay, that's it. Good. All right, so that's duty of care. Gone. All right, let's get on to breach of duty of care. Okay, so breach of duty of care, if you have a traffic accident scenario, is always an issue. Again, don't forget, in an examination question, whenever you're dealing with any question on negligence, write down the elements. Basically, it's a definition. You get the marks, but also it guides you in the rest of your answer. Okay? So how do you know whether there's breach of the duty? Well, it depends on the standard of care. Must know Glasgow and Muir. Glasgow and Muir says the court will look at the standard of the reasonable defendants in the circumstances, which means the standard of care varies depending on who the defendant is and the circumstances. It goes up and down. So Glasgow and Muir, it was the tea urn wheeled into the tea room and some young boys got scalded. So, was a duty of care owed? Yes. But was there breach? The court said no. Why not? Because in order for there to be no injuries at all, the owner of the premises would have had to clear the room totally of people every time the tea urn came in, and on the facts, this was not reasonable. And you've got a pretty good extract from Glasgow and Muir on page 51. The reasonable man is presumed to be free both from over-apprehension and from overconfidence, but there is a sense in which the standard of care of the reasonable man involves in its application a subjective element. It's still left to the judge to decide what, in the circumstances of a particular case, the reasonable man would have had in contemplation, and what accordingly the party sought to be made liable ought to have foreseen. So it's really up to the facts of each case and the judge in the particular case. Right, good. And so what is the standard of care does depend on who the defendant is. And if you've got a child, the standard will be that of an ordinary child of that age. And in all of the three cases, there was no liability, there was no breach, because children were acting like children. Okay, I mean, when you're on the mass torture, MTR, okay, the people who move around are normally kids, right? They're hanging out, they're doing their exercises on the bars, and running around. I like the one where they go round and round. I get dizzy looking at it. Anyway, but that's what kids do, okay? All right. Particularly Orchard and Lee, that one where the supervisor was injured. Why? Because it's in a playground and kids were running around. It's silly. These should have stayed out of their way. All right. Okay. And then standard of care for people. This is should know, not must know, everybody. You're unlikely to get a question dealing with professional people, but of course some interesting cases, particularly Wong and JSM, in which the young lady solicitor was held to be negligent. She says, I just followed the normal practice in Hong Kong, completion by undertaking. That's how it happens in Hong Kong. Non-simultaneous exchange of money and documents. The purchaser pays over his money, but doesn't get the title documents till about 4 or 6 weeks later. That's how it works in Hong Kong. The Hong Kong Court of Appeal agreed, but the Privy Council disagreed, because in Wong and JSM there was this extra risk involved in that the vendor solicitor was a one-man law firm, so it only takes one signature to withdraw the money from the trust account, and that's what happened in that case. So the lady solicitor was held to be negligent. She should have advised her client to insist on formal completion, simultaneous exchange of money and documents. Okay, all right. But it's interesting now that the standard agreement for sale and purchase in Hong Kong has been amended, so that when the balance of the purchase price is paid to the vendor solicitor receives the money in the capacity of agent. And if you pay an agent, you've paid. You don't have to pay again. Because in Wong and JSM, the purchaser paid over the balance of the purchase price, but then the vendor solicitors ran off with it. Well, so the purchaser had to pay the balance of the purchase price again. They were not happy. Who do you sue? The solicitor involved for negligence. By the way, all law firms in Hong Kong must carry insurance covering negligence claims. All right. Okay. So, with regard to the standard factors, probably Wishing Long Hong must know. What is the standard of care of a reasonable employer in the circumstances? Well, in Wishing Long Hong, a reasonable employer would have provided sufficient tortures to the employees. Remember, the employee fell down, was killed. And the issue here, well, did the employer owe a duty of care? Yes. Was there breach? The court said yes, because a reasonable employer would have provided more tortures, so they were in breach. What was the other issue in Wishing Long Hong, everybody? Think of defences. What was the other issue in Wishing Long Hong? Well, if you fall down, are you at fault? If I fell down, would I be at fault? Yes! So what's the issue? Contributory negligence, got it. Wishing Long Hong, everybody, really good case. Really good case, because it's on two issues. Number one, was there breach of the duty of care by the employer? Court said yes. And the other issue, was there contributory negligence? Court said yes, and we'll deal with that when we deal with defences later. And of course, I think it was 20% reduction in the quantum of damages. Okay, so Wishing Long Hong, good one on the standard of care, but the other must-know case, of course, on standard is car drivers. Must know Nettleship and Western. Must know, must know, must know. So Nettleship and Western, what was the standard of a car driver? Well, it's not Glasgow and Muir, because with car drivers, there's only one standard for all drivers, and that is the standard of the competent and experienced driver. So the learner driver was in breach of the duty of care. Okay. The learner driver owed a duty of care to the instructor who was injured in the accident. Was there breach? Yes. Causing damage? Yes. But what was the other issue that the learner driver relied on? What was the defence of the learner driver? It's on the screen. Contributory negligence. Because the learner, the instructor, was at fault. He wasn't a very good driving instructor, was he? Your clients are not supposed to crash when you're teaching them how to drive. So interesting. The learner driver raised the defence of contributory negligence, and look, 50% reduction. So Nettleship and Western, good case, 2 for 1. Nettleship and Western is leading authority on the standard of care for drivers, and it's a very good example of contributory negligence. Okay. All right, everybody, we've done pretty well. Anybody any questions? Okay, well, let's have a 10-minute break.